Article 13, Mitigating Circumstances. The following are mitigating circumstances. Number 1. Those who mentioned in the preceding chapter when all the requisites necessary to justify or to exempt from criminal liability in the respective cases are not attendant. Number 2. That the offender is under 18 years of age or over 70 years. In the case of the minor, he shall be proceeded against in accordance with the provision of Article 80. Number 3. That the offender had no intention to commit so grave a wrong as that committed. Number 4. That the sufficient provocation or threat on the part of the offended party immediately proceed the act. Number 5. That the act was committed in the immediate vindication of a grave offense to the one committing the felony, his spouse, ascendants, or relatives by affinity within the same degrees. Number 6. That of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. Number 7. That the offender had voluntarily surrendered himself to a person in authority or his agent, or that he had voluntarily confessed in guilt before the count prior to the presentation of the evidence or the prosecution. Number 8. That the offender is deaf or dumb, blind, or otherwise suffering some physical deficit which does restrict his means of action, defense, or communication with his fellow beings. Number 9. Such illness or the offender would diminish the exercise of the will power of the offender without however depriving him of the consciousness of his act. Number 10. And finally, in any other circumstances of a similar nature and analogous to those above mentioned.